everyone. Welcome to February 2023's HYLA Lunchtime CLE. Today we are joined by Denise Peterson, who's very kindly agreed to come and talk to you on the subject of negotiation, key skills you were not taught in law school. I'm going to let Denise introduce herself and kick things off. We will put the course code in the chat, so please look out for that and please self-report your CLE. Thank you so much.
All right, good afternoon, everybody. Thank you for agreeing to share your lunchtime with me. By way of introduction, I'm an attorney here in Texas. I graduated from South Texas in 2010. I actually just wrapped up our class here. I'm the clinic adjunct for mediation and will, I believe, be teaching the negotiation class here this upcoming fall. My full-time practice is mediation and arbitration. I handle civil mediations. From real estate construction, personal injury, employment, and arbitration. I'm a panelist for the AAA. I'm a chair for FINRA, and I'm a fellow of the Chartered Institute of Arbitrators of London. So I've got some qualifications, but mostly we're going to talk about the gap between how we teach negotiation in law school and the real world skills that you need to successfully negotiate every day. So I'm sure that, actually, before I start with that, some CLEs people prefer that questions get happening at the end. I actually have the Q&A open. If you have a question as I'm going along, if I think it's a good time to answer that question, I absolutely want to do it in the moment, because sometimes the context is really important for the question. So please feel free to use the Q&As for questions, not the chat, because I can't have that many boxes open on my computer. I'll miss one of them, but use the Q&A function for that. Let's see if I've got the bar thing there as well. All right. Most of you might be familiar with this book. Almost every single negotiation program, whether it's at law school or business school, uses Fisher and Urey's Getting to Yes. This book is a product of the Harvard Business School, and it is almost as old as I am, and that's saying something. This is a really good book for some really basic, fundamental, tactical, and strategic principles, but it relies on a fundamental concept that isn't true in the real world. It assumes that all parties in a negotiation are rational actors. Now, I don't know how long some of you have been practicing law, but I don't run into a lot of rational actors, people who are looking purely like a computer at something and going, well, if this is 5 and this is 7, then the right answer is 6, because that's the meat in the middle. It's the perfect number. So this is a great book. And it's great foundational for certain skills. But if this is where you started, we got to take you to the next step. We treat conflict in American culture as generally kind of a bad thing. We sort of exaggerate that in the law. But if we think about it realistically, conflict is the business of law. That's why we're here. We're either writing contracts to avoid conflict as part of a transactional negotiation, or something's happened, something's broken, and we're coming in from the litigation side to handle the conflict that's arisen out of a set of instances. The way we teach law school is we talk about being a zealous advocate for our clients. We talk about it as being, we're supposed to go out there and argue their side and win. Their options are win and win, because that's what our clients are expecting from us. But the problem with that fundamentally is you get into this like tit for tat entrenched position thing where it ends up feeling like two people yelling at each other over the net in a tennis court. It just doesn't work, because there's something that needs to happen when we're not directly in court arguing our cases, and that's negotiation. And negotiation and zealous advocacy aren't a good fit in the way that zealous advocacy is kind of looked at in modern contemporary law. So, first of all, why did your client hire you? This is where I always start with people. Why did your client hire you? They hired you to solve a problem, either because they're looking into going to a new area, it's contracts, it's business, they got a new joint venture going on, or they're coming to you on their worst day of their life because something has happened, whether it's a personal injury situation, whether it's a construction failure, whatever it happens to be. it's an employment situation where things went really wrong and someone's saying there's discrimination, the other side's saying that there's not. But they want you to be the person, they're entrusting you with their problem to solve it. Now, however they picked you as their general for handling this problem, they're trusting you to use the right strategies and the right tactics to handle this. And with our clients, and I have to apologize, we're not using a PowerPoint today because Zoom is having problems with sharing screens. If anyone else has noticed, feel free to raise your hand if you've seen it, by the way. Where it's been causing issues with the Zoom, so I'm having to switch my PowerPoint to printouts. So I got it going over here. So if I'm looking down a lot, I apologize. It's because I couldn't quite do this the way I had planned or worked on it last night. So the thing is, they want you to be their effective voice, not their zealous voice. They want you to be effective and efficient in solving their problem, whether it's creating or negotiating a contract for with a vendor, or if it's resolving an employment issue, like I mentioned. They may not know the law, or even if they do know the law, they may not trust the American legal system or believe that they will be treated fairly inside of it. And they may have personal reasons for this. They may have historical reasons for this. They may have cultural demographic reasons for this. But they're relying on you to be their protector, their voice, and their general. I kind of like the idea of a general. I've been sort of playing with that idea recently. So what is conflict? Conflict consists of three things. There's the people issue. There's the process issue. So the people issue is the relationship that created the conflict or the potential conflict. There's the process issue. How are we going to handle the conflict? And there's the problem itself, the substantive reason why we're there. This is the tripod of things that we have to address. And the way we do this, for the most part in the law, and also in our everyday lives, is through negotiation. It's not in the courtroom. We eventually can get there, but the majority of what we do is we negotiate. Negotiation is literally the thing we do every day. When we're talking about where we're going to go out to lunch, right? Where do you guys want to go to lunch today? Oh, I want to go to Treebeards. But it's not chicken fried steak day. Oh, okay, you're right. We should go there Thursday. That's a negotiation. It's parties trying to come to an agreement about doing something as an outcome. What Fisher and Urey don't teach in Getting to Yes, and what doesn't get addressed in most law school programs, and which is going to be the meat of today, so thank you for allowing me to go through this long introduction, and I really do hope there's questions about this, is what the term that's currently being used came from a man named Barney Jordan, and it's called shadow negotiations. And I kind of love and hate this term at the same time. He's actually Afrikaans, and he lives in he's a professor in Belgium. This is a book I'll give the details out for the end. This is a book that just came out this past year. It is, by the way, absolutely fabulous on both the transactional and litigation sides. I highly recommend it. And actually, this may be one of our textbooks next year. Uses the term shadow negotiations, which to me a little bit feels like a little spy versus spy-ish. It's like, what are we doing in the shadows? Are we like sneaking around behind, the opposing counsel, like listening in conversations or something? But what he's referring to is all of the things that happen outside of that final space where serious settlement discussions again. Jimmy, I'm going to make sure that the book gets emailed out to everybody. And by the end of the thing, I promise to put that in the Q&A too about what the name of the book is. But it's Negotiation and Dispute Resolution for Lawyers. The guy's name is Barney Jordan. It's Jordan. It is dense, it is thick, it is heavily cited, and honestly, I love it. There's a lot of really good conversation in here about methods of conflict, defining conflict. And the problem is I only had an hour with y'all. And there are 15 hours of things I would love to talk to you about, but this is the one core skill that I picked to talk about today, which is the shadow negotiation space. I break this down. So this is everything outside of that final room. It's everything that happens before you walk into that room. And for me, it consists of really three things. First of all, I want to talk to you about attorneys being attorneys in an attorney space. What can I do? Can I do this? All right, we got that one. Good. We have over 100,000 people who are members of the Texas bar. They either live in Texas or they're somewhere else out in the country that, they got a bar, they're barred here as well. despite that, we're a relatively small community, and that happens through things like our board organizations, our specialties. Different groups tend to know each other very well because you're either are in court at the same time, you're going to CLEs together, you're specializing in the same areas of law, or you have similar interests that bring you together. It could be Habitat for Humanity. But you build a reputation. People know you for certain things. Now, your advertising on the billboard may say that you're the Texas Hammer, but how you are actually in person may be quite different. And your reputation in the negotiation space is one of the most critical things for you to build, because it gives you a lot of clout. And it's not necessarily clout in the sense of like a judge sitting in a black robe at the desk kind of thing, but in the type of respect you get inside the legal community for how you handle your clients' conflicts. And I would like to make a note that not everybody's going to have the same negotiation style, and that's okay. But the tools and tactics that I'm talking about go across all styles. Your reputation is also built out of how you've handled negotiations in the past. What do people expect from you? When I was still litigating full time, I might get a phone call from a colleague saying, hey, I just got a new case with so-and-so. Have you ever worked with them before? Yeah, I had them as opposing counsel on the XYZ matter. What were they like? I can't get this guy to return a phone call. How did you handle this with them? Did they ever stop yelling at you? So people will talk about how you handle conversations with your colleagues about client matters. And that becomes your reputation in the negotiation space, becomes part of it. And that's really important because you can use that for your clients. Do you want to be known as the yelly person? Probably not. There is a time to yell and there's a time to be quiet. But if you really want to be able to use your reputation to be a more powerful negotiator, one of the core skills that is required to do this is to build rapport. And it's a term that gets used a lot, but I'm going to use an example from what I did in my negotiation competitions back in 2000 a while back. We were the year before us. I got talked into negotiation competition because they were like, hey, they always get to go somewhere cool for the finals or for the regionals. I was like, yeah. I said, yeah, last time we got to go to Anaheim in California. We hung out at Disneyland all day, one of the days. I was like, that's awesome. I got Topeka, Kansas. On the good side, I got to see the side of Brown versus Board of Education, but I got Topeka, Kansas after a big snowstorm in late November. It was not the best. But we went into the space the day before. And so we kind of knew where the rooms were. And that morning, we met up with, we were walking around, we started introducing ourselves to the other competition teams. We knew all their names. By the time our first rounds started, I knew the names of my competitors. I knew their spouses or significant others' names. Some of them had kids and dogs and cats. We knew it all. We had a conversation already going. And the judges were blown away because the round went smoothly. I remember that being written down by one of the judges, the smoothest round they had ever seen. Because we had taken the time to build rapport. We had taken the time to build a connection with our opposing party, our opposing counsel rather, that was different and separate from their relationship with their client. And in doing so, created opportunities and space for discussion and handling the really hard stuff. So how do we do this? This is not easy. And I do it every day because that's what I do as a mediator. I'm going in and I'm negotiating on behalf of the parties, right? I'm kind of like a proxy for the parties in a lot of cases. The first thing is people talk about trust in negotiation, and that kind of gets people's backs up a little bit. It's like, well, I can't trust the other side because look what they did. This is why we're here. That's ridiculous. And you're not wrong. That's not a wrong way to feel about it, because if the parties trusted each other, we probably wouldn't be in a litigation-based negotiation, right? Thank you, Houston Pollen, for keeping my throat running dry. But you can be a trustworthy person. You can actively act and demonstrate trustworthiness. And there's a bunch of ways to do this. I'm trying to watch chat too. I think I saw something go up in chat. No, okay. Sorry, let me see if I can get chat. I do have chat open. Okay, I can see chat now. Good. So if you have things in chat too, even just comments that aren't a question, you can drop those in chat. Keep your integrity. I'm not talking like, people say, oh, you have to act like a lawyer. People like, keep your word, be trustworthy, act like a trustworthy person. And that's really important, because if that will extend people being more willing to tell you things. It's hard to get parties working together towards a joint solution on anything. But if you demonstrate trustworthiness, people are going to listen to you more and give you more opportunities to advocate for your client in a way that is not zealous advocacy, but is effective communication and effective explanation. One of the ways I do this is by setting tone. I come into a negotiation, and this is also true when I was litigating. It's like, hey, good morning. I used to be at the DA's office and doing protective orders for victims of domestic violence. And I would have an attorney come in and say, look, we're contesting this case. And I said, okay, here's all my stuff. And I would chat with them about things like, any trouble parking today? I see the Astros are playing. Do you guys have any problems getting parking for the courthouse? How about the Mets sort of questions? So setting a tone of conversation, of openness, like, hey, I'm not sitting here like waving a file at you saying, how dare your client have done this to my client? How dare? Instead, I'm saying, hey, how are you doing? Because we are not our clients. And we say that a lot, but it's really true. And when we're in negotiation space and we're trying to establish rapport, that is doubly true. So that use of small talk is really, really critical. It sets a tone. Use an honest interest and a concern for your opposing counsel. If somebody's running late, like, hey, are you okay? Do we need to reschedule? Show flexibility. And some things you can't, and I get that. But if it's a phone call or an email or something you guys were trying to connect on, say, hey, like, is this just it sounds like it's a rough time for you. Do you have time to actually sit down and focus on this with me right now? There will be times when somebody will say to you, you know what, if I could call you back in an hour, if we could pick this up tomorrow morning, because, the water main just went out in our building and things are just insane around here. Yeah, because I want to have your 100% attention. So if I can't have that, take care of this, and they're going to remember that. And that's where you're building your reputation. That's also where you're building rapport for the other party. And I'm going to tell you what the benefits of this are very shortly. So demonstrate trustworthiness, set tone, basically begin as you mean to go on. If your first communication with an opposing party is, hi, I'm Denise Peterson. We filed our case today against your client because they are a horrible, horrible, horrible employer and human being, and we're going to take you to court, and your client's going to be paying us $15 million. That's your first communication. The other side's going to be like, go jump in the lake. I'm not going to talk to you, because you're coming in and saying, you're just coming in, you're coming in hard. And those things all may be true, but it isn't necessarily what we have to lead with. You can start off with like, hey, my name is Denise Peterson. I don't think we've had a chance to talk before on any other cases. I'm going to be representing a former employee of your clients in their claims against XYZ Corporation for sexual discrimination. Oh, I hadn't seen anything on that case yet. I hadn't heard anything from my client yet. Okay, well, wanted to kind of give you a heads up. We're going to have to go through this process, but I wanted to let you know that this is going to be going on. Here's all my contact details. As things develop, I'd like to talk to you about the process. I want to talk to you about when are we going to handle mediation? When are we going to handle discovery, meet and confers, depositions? I want to make sure everything works with everybody's calendars, especially because, hey, if we're filing now, we're doing this thing now, we're probably going to have to handle some of this over the summer. And if you've got vacation plans, I've got vacation plans. I don't want it to mess up with any of that. And true story, I had a mediation where we ended up negotiating. This mediation ended up being about discovery. The two attorneys had just not been able to communicate with each other well about that. And one of the things was literally about where the attorney did not want to do depositions during a certain range of time, is because their only child actually was going off to college. And they wanted to be there for the move-in days and a few other things. And they had some concerns. They wanted to be able to stay around a few more days. And that ended up being part of the negotiation, but there was an opportunity lost there, because if somebody just said like, hey, my first kid's going to college, I really don't want to miss any of that part. Can we block out these days as just being no good for anybody? Because I promise you, the other side's probably got other stuff that they just don't want to be doing a deposition on that day. And you create conversations about the process and make sure they're very separated from the issues of the case. You can have good conversations about the process of litigation. Will it work in every case? I'll tell you right now, no. Okay, there are people out there that they are just, that's their school. They're like, nope, I do everything this way. And the other side, it's my way or the highway. And if the other side doesn't like it, they can go pound sand. All right, I can't do anything about those people. But for the majority of your cases, you can have these conversations, because collaboration on process does not preclude that you are in a competition, that you're advocating, that you are representing your client in good faith and zealously. It's sort of like did we just have like a sports ball thing? It's good sportsmanship, right? It's shaking hands with the other side before and after a game. It's showing people that you are trustworthy and that this is not that you are trustworthy, but you don't necessarily have to trust the other side. And I emphasize that you don't have to trust the other side's claims. You don't have to trust or believe them. They have to substantiate them, right? That's why we have discovery. But one of the biggest ways that I've built rapport and used that right into the negotiation space is by shutting up. If I can get a conversation started with the other side, whether it's a phone call, a lot of people seem to like just have Zoom instead of phone calls, which is fine. Maybe I get to see your cat. That'd be cool. But I shut up and I listen. After we get through that little chit chat phase, hey, how you doing? I'm doing good. I've got this random thing going on, which is kind of hilarious. Oh yeah, I've had that too. I had an attorney call me out of the blue yesterday, wanted to know about me as a mediator because they'd never worked with me before. And I love those phone calls. And, our chit chat portion of our banter, our chit chat was about the fact that my laptop had done a random reboot on me out of the blue. And I was waiting for it to come back online because I was apologizing. If I can't look up your case right now because I'm waiting for all of this to come back for me. And he goes, oh man, because I only use my iPad now when I go to trials because I've had my Windows box reboot on me too many times and mess things up where I have things set up for hearings. So we had this whole moment of shared experience that we now have. And that builds what I call sort of like the rapport reservoir. And I'll talk more about that in a minute because the reservoir can get drawn down and sometimes it's drawn down fast, but you might want to use that reservoir of good feeling, bonhomie, to deal with the harder stuff. It kind of greases the wheels. The first thing is to shut up and listen. Okay, you're saying your client, what happened? Oh, when did that happen? So listen, and when there's pauses or you want to get sort of more information, open-ended questions. I know this sounds like law school 101 in some ways, but this is really true. When someone's telling you about their client's claims, don't come back with, no, that's not what my client said happened. Because you're going to shut it down, you're going to entrench the positions, and that whole time will be wasted. Whatever work you've done into creating the chit chat and the banter to get the conversation going and this person opening up is going to be gone. When did that happen? Oh my gosh. Really? What was that like for them? Okay. Oh God, that sounds, you don't have to believe them, but you want the other side to believe you understand their claim and understand where they're coming from. They know you don't agree. Otherwise, you wouldn't be in conflict, okay? But listen. Who, what, when, where, and why. And use time before responding. If they come back with a question for you, like, well, what did your client say about this? That can be a little fraught because you may not have enough information yet. Consider before you respond. If you pause before you respond, what people think, even though your mind's going 900 miles an hour and you're panicking, like, how do I answer this? Because that's what my brain's like. They think you're being thoughtful, which is cool because it makes you seem even more centered and approachable and listening. You can redirect it by saying, well, I want to understand a little bit better what they were saying about the damage to the front of the car. Or you can pull things back and say, you can also honestly just say, I haven't actually had enough detail from my client. Like some of the things you're telling me are things I need to go talk with my client about now. And then I want to schedule a time to come back with you and actually answer that question for you. But right now I can't answer it. And that goes to trustworthiness and believability, because it all comes down to being genuine in the conversations. Be yourself, be you, be honest about like, hey, I don't know this yet. I'm trying to figure it out, or I'm not sure that like what I'm hearing from you and what I've heard from my client, there's some disconnect in here that I want to clear up with them before I respond. But I really like that we have had this conversation. Thank you for taking time to have this conversation with me. In doing that, you're creating positive expectations out of communications with you. The other side, your opposing party, your opposing counsel, your counterpart, is actually going to look forward to, or at least not dread, talking to you, because they know you're not going to be slamming the table and flipping it over. And stating things like I just did, which is, thank you for making this time. I don't have the answers you need right now. Like I just don't have them, but thank you for taking the time. Well, actually generates good feelings. There's a whole bunch of studies that show that if you can give praise or genuine, not made up, not like, thank you all for being here today for this mediation because we would like to settle this case because it's in the best interest of the parties. That's fake. Okay, we all know that that's fake. It feels fake. If it feels fake when we're saying it, it definitely is fake to the other side. But if we're generally like, you know what, I really appreciate this time that we talked about this. And you can use that to launch board right then and say, hey, I'd like to schedule a follow-up conversation with you. We still got to nail this deposition issue down, but I don't know my total client's availability. You know, can I call you back on that date? You're just springboarding off those good feelings to get an agreement. And there's one of the secrets. As you start to get small agreements, they act to create bigger agreements. The more agreements you get with people, the easier the big agreements are to get to. One mistake that I see people make quite frequently, though, is after they'll have a great phone call where they've built rapport, some chit chat, you know, based on whatever, whether it's a sports game, the Houston weather, which is always a safe conversation because like we've always got something going on with our weather. How the astros are doing, courthouse parking, shared experiences. Maybe somebody is also involved in a bar organization like HYLA, like you are. Like, hey, are you going to the next event? Have you ever done this? You know, whatever it happens to be, or something just off the cuff. Like when I got called yesterday and I'm staring at my laptop screen, waiting for it to come back on during the middle of a reboot. You've used all of that. And, but then you follow up with what is a good practice thing to do, which is an email. I'm gonna send out an email now. An email is going to say, you know, summarize what we just talked about. So we've got a memorandum. And in case you, by the way, did remember something incorrectly, hopefully the other side will come back and say, no. I didn't say next Tuesday, I said next Thursday. Okay, great, we can fix that. But oftentimes the tone of our emails does not match our conversational tone. And part of that is because honestly, writing emails is hard, and I hate writing subject lines with a passion that burns deep within my soul. I cannot write a good subject line for an email. I cannot. And I wish I could skip it, but we know we can't do that. That's the format of the email. We have to have that subject line, that artifact from back when we used to do letters with, you know, handwritten letters with regarding memos. Come across as formal, combative, or jealous advocacy, or zealous advocacy. You know, you have agreed to deposition at this day, at this time. This is going to be your expense to manage this, and you know, blah blah blah. And it may be because that's the way you want your client to see the conversation of having happened. But if I, after a good conversation, get an email that feels very in my face and very like declarative and not recognizing what we just did, I'm going to be a little ticked off, and that level in the rapport reservoir is going to drop. It's called rapport burn. And you want to choose when you're using up the rapport you've built up, not accidentally do it like this. So make sure that your tones of your emails and the contents of the emails, or whatever follow mechanism you're doing, match that. Any questions so far? You guys have been a quiet group. Y'all just, is good lunch today? I don't have any comments. I don't have any questions other than the book. Okay. All right. Maybe you're saving them for the end, which is also cool. All right. The last part of this particular part is repetition. And it's not enough to just do this once. you have to constantly make sure your relationships are built, because reputation is built over doing the same thing over and over again. But the other benefit is that by reputation just becomes practice. It becomes very, very easy and straightforward. So I'm looking for a note, and I apologize for this because like I said, we lost the ability to share screen. I'm trying to describe something that's on a share screen that you guys can't see. So how does this work out in practice when we get to the big stuff? When we get to having the hard conversations. So part of it comes out of our past, is that building rapport, sometimes people equate with being a pushover. And I wish I could show you the picture that I have, because it's a picture from a book I love from Terry Pratchett, of a witch called Nanny Ogg, who's this just giant squish of a human being holding her cat Grebo. And Nanny's just like, oh, he's just an old softie, but Grebo is the most murderous cat. Like, he is Mr. Murder Paws on the planet. And so when, you know, he goes out and like protects her, he's the steel claws in the velvet glove. And that's the thing. Rapport builds the ability to have communications and conversations. It doesn't mean that you are negating your ability to have difficult ones. And in fact, it actually sets you up to handle them better. Going back to talking about the problem, the substantive issues, if I have got a reasonable amount of rapport built out with my opposing counsel, I need to talk about the substantive issues. One thing that immediately happens is that your opposing counsel is less likely to consider you and your client's issues to be one and the same. One thing that I see happen a lot, and people talk about all the time on the various lawyer groups, is they get personally attacked. You don't know what you're talking about. Your client doesn't know what they're talking about. Those kind of conversations are less likely to happen if you've built some mutual respect over the process. And we were talking about the problem. Where this comes to help is this way. I had a case a little while ago where this is mediation, but once again, I'm acting as the proxy negotiator, and one side wanted clearly communicated certain issues. Like, I have explained to them over and over again that if we win on this, we're going to get our attorney's fees. So the fact that they've been getting, this is a case where they actually did have a real trial date. Like, it was going to go. I think it was in Judge Roth's court. It was going. It was going to go one way or the other if they didn't settle. And the numbers they've been offering us don't even cover the attorney's fees. So the whole thing doesn't make sense to us. The numbers that they're offering don't make sense. I've explained it to them and explained it to them and explained it to them, and they're not listening. They're not listening to me at all. I go talk to the other side. I'm like, hey, you know, you've even admitted that you think you've got some liability here. How is that going to play out when the jury awards some of the money that you're asking for, and then awards, you know, attorney's fees and costs on top of it? And they're like, that's going to be tough for us. Why is it going to be tough for you? Well, my client doesn't have a lot of liquidity right now. Coming out of COVID, they had a bunch of other expenses that happened, and this is a small business owner. She actually had COVID herself. She didn't work for 6 months. So yeah, when this whole problem happened back in 2019, there was a whole different situation with the ability to pay this kind of money. But if they win now, we're just going to have to, try to figure something out, because she doesn't have this kind of money. Because one side had been so busy trying to demand that the other side understand where they were coming from and have it acknowledged in some way, they weren't listening to the fact that there was no opening for the other side to have the conversation I was then having with them, which was about capacity to pay. They knew that there was liability. They knew there was liability. They knew it had to get addressed, and that a jury was likely to award that, and they would probably get all their attorney's fees, and that those numbers were bigger, but the numbers that they'd been presenting were based on this woman's capacity to pay. Because there hadn't been any good basic communication up until then, all of that had gotten missed until the moment in mediation. And this happens over and over again, when the focus is so much on, I want to make sure you understand our arguments and why we're going to win or why we're going to counter all your stuff and we're going to win, either plaintiff side or defense side, or, instead of finding out what the other person thinks that they have. And there's a case I've got coming up and coming, which involves a JV with a joint venture that got created about flipping houses. And these people have been so deep in their conflict over expenses. The new issues arisen that they can't even talk about, which is why we're going to be mediating. And that's that the property is about to go into foreclosure because the bridge loan for the construction has run out and it's in default because it hasn't sold yet. Oh, I love this. I got a question from Mr. Ritz, but I'm assuming that you're Mr. I apologize. How do I deal with a situation where opposing counsel doesn't usually practice a given area of law, so being loud and aggressive to cover for it? Oh man, yeah, I hate these. These are tough. These are tough. You don't want to cause them to lose face, but they make the case difficult to conduct and negotiate. Okay, you're right. So first of all, open a conversation about them with the process. Talk about them like, if we've got to do, in this case, we've got to do X, Y, and Z, or I'll take a one that it happens all the time. We don't teach RCLA in law school usually, unless you take a construction law class specifically. So a lot of people plead RCLA as DTPA, and then there's a problem where if they didn't do the RCLA stuff, they may not be able to recover their damages. So there's a lot of different places to deal with this. I'm going to talk about some different specific examples. One thing that I've done is say, look, I want you to look at the statute with me. All right, because this is where I'm not understanding where this part happened. Can you show me your facts or your things that do this? So I try to turn it into a collaborative discussion. Show me, turn it into show and tell. All right, show me where this happened. Okay, all right. Well, that's not, when I tried this case last time, that wasn't the standard, or here's the case law I've got on this. Anonymous absentee, I am going to answer that question, even if we go into overtime, because that is a really important question. So one way is to go into collaborative mode. Show me this. Show me how you're going to get this. Say, hey, you have when I file summary judgment, on prong 3 on a slip and fall case, which is usually fair notice on a slip and fall, notice and an opportunity to cure. I believe your client got hurt. Like I've got video that shows that they fell and shows that they got hurt. And my gosh, the ambulance had to come pick them up because she couldn't even get off the floor, but can you show me where this happens? So it's kind of like, instead of trying to go head on, if you got two things going head on, all you get is this, right? But if you can redirect into show me, tell me, can you demonstrate this? Because here's what I'm going to show. And, this may end up being a jury fact. And sometimes I do that too. I say, look, you may be 100% right, but I'm going to argue against you. And this is kind of a jury fact. And depending how a jury goes on this, it could go really great for you or really great for us. So sometimes you can get them to start thinking about that and talking about that. But a lot of times also, if they're being really aggressive and loud in the beginning, that takes energy and people run out. So like, let them run with it for a bit and just listen, take down notes. You may find out stuff about their case they don't actually mean to tell you because they are so busy ranting on behalf of their clients. I've had disclosures made to me. God, I can remember, it was going back to what I was doing, the protective orders, where he's like, look, this, she didn't get those bruises from this time he hit her, it was from a week earlier. And I went, oh, really? So you're telling me that you just admitted to me that your client hit her a week earlier too? Oh yeah, I'm getting the protective order now. So a lot of times when people get into that loud and aggressive mode, they're not watching what they're saying. The best thing you can do is be silent. So I am a female mediator. I'm going to jump over to this other question. And I'm loving these questions that are coming in. Please keep them coming. And if you want follow-up questions, Mr. Ritz, like follow up if I didn't answer you enough, but I'm going to answer this other question in the meantime. The question is, and I'm going to edit this a little bit to keep this more anonymous. As an experienced female attorney who's also a woman of color, I find that a lot of attorneys approach our interactions already having discredited my position, argument, and demeanor. Honest answer, yeah, this is a problem. Our bar is 78% white and 64% male. What a standardized attorney looks like in the state of Texas is a white male. I'm not dissing on anybody. That's just a stat, okay? And we all know that we have a lot of issues out there. There are going to be attorneys that come in with absolutely crappy attitudes. I'm a female mediator in a male-dominated section of the practice of law. I am white. I'm so white I glow in the dark. But I still deal with issues directly just on being female mediator and also not being a former judge, because most of our mediators started off as former judges because that's just how the whole practice started. So I look at it as establishing authority with the other side. And there's a number of ways that I do this. One is, to the extent I can, I ignore their attitudes. And that's hard. And it's an emotionally hard thing to do. But especially if someone's being like, very like, well, you don't know how, like, these kind of employment law cases happen. Like, this is a thing where this is going to happen. I'm like, okay, tell me more. Tell me more. I actually use that to get a lot of stuff out of them and pull it out of them and use it for the benefit of my client. In introductions, I will oftentimes use or reference a position or something I'm doing that is a position or something of authority. Like the fact that I'm an adjunct clinic at South Texas. Okay. Oh yeah. When I was teaching mediation classes, what you teach, yeah, I'm an adjunct professor at South Texas. That has status to it. So I look for things that are external status markers that are of value to the other person. And to the extent that I can tie myself with it to kind of break them from seeing me or deciding that I'm something else. There are some people you will never reach in this. They just think that, women of color, people of color should not be in the practice of law. They're thankfully becoming more and more of a minority, but they're real, and you can't pick who your opposing counsel is going to be. So it comes down to finding ways to establish your authority. I do it during introductions. I do it in the way I handle communications, and ameliorating the effects. Honestly, a lot of times it's just letting them rant and take notes. Sometimes they're hilarious notes, but just let them get it off their chest and say, okay, appreciate all that. Appreciate your experience. Appreciate your experiences. My experience has been a little bit different. Can I tell you about, when I last handled this in trial 2 weeks ago in front of so-and-so, or in the, in the 30 plus trials I've had over this particular issue, I've seen that play out a little differently than what your experience has been. And hopefully they're at least going to listen, or if not listen, they're like, wait, she said she had 30 trials. Wait, she's been practicing this long. I've also had that issue with, and I'm aware that there are issues also even looking young. People are like, you're too young to be a lawyer. No, it's not necessarily true. So we'll never be able to fix that issue where people judge others and discount them based on a physical appearance, whatever it happens to be. But we can establish our authority and tie ourselves to external values. We can also use it as a tool. Do I have more questions? Because I like these questions. I will want to add, I do add one footnote to what I was saying about, which I think is important here too. I'm not in any way condoning, enduring anybody's bad behavior, use of slurs, derogatory language, or derogatory treatment, okay? It is also absolutely appropriate to decide where your line is. And this is also honestly in a way of building rapport. I have given you respect and I have listened to you, but what you're saying and the way you're acting towards me is not as a colleague, as a member of the bar, but is extremely derogatory and offensive. I want to be able to collegially work on the process issues in this case. I want to work with you on getting things scheduled in the way things make sense so that we can handle our client's conflict and get this resolved. But not good with this treatment. And if you're going to continue it, I'm not going to be comfortable doing, I'm not going to be comfortable having another phone conversation with you we're going to have to maybe reduce to just emails, and basically let them know they're checking themselves before they wreck themselves. But if somebody is offensive, and a couple of my early mediations that I did, I actually ran into this. I just ended the mediation, I ended the discussion. It is okay to end the discussion. There's nothing in our practice of law that requires us to endure abuse. Absolutely nothing. What I am trying to teach is ways to build relationships that help us stand out better as attorneys, to be effective negotiators and get the things our clients need, and to have a reputation inside of our community that makes every interaction in the future get easier and easier, because you've built up this reputation of being able to build rapport, and you're open to negotiation and you're open to listening. But there's nothing in what we do that should ever have to have us subject to abuse. I don't care who you are. No one should be ever subject to abuse. And that includes like even inside firms as well. If there's someone above you or below you or next to you that is abusive, like that's not okay. Did somebody else have a raised hand? There was a raised hand thing. I can't call on people because it's a webinar. But if you put it into the Q&A, I can answer it. All right, so we're coming up on 12:50. I've got 10 minutes left. Things I also wanted to discuss. So when you are having to, and I'm going to keep talking until somebody has another question. I'm hoping this is helpful and this is good. When you are taking that moment to then start presenting your client's claims, use language that actually, if you can, if you can, is inclusive of the other side. When we are looking at the medical bills for this, the total medical bills are X, Y, and Z. My clients continue to exhibit these issues. If it's something where you can avoid words of blame, that helps. It's like, look, you're responsible. My client should not be responsible for the medical bills that came out of this. My client should not be responsible for fixing the mold issues that have now happened in their home because of X, Y, and Z. My client should not be responsible for paying your client for not doing their maintenance and their air conditioning that caused this mold issue. Some of this may be attributable to things that happen on my side, but they didn't do the basic maintenance at their home. You watching how you say that, so it doesn't become the kind of language you would use in court, but rather is a look, we've got this problem, mold in the house, it's got to be solved. Who's going to be responsible for what, and how are we going to address it? Pulling the language back from the courthouse presentation and finger pointing, which is what we do in court, right? That person there made the choice to not have an inspector come out. And because of that, this issue wasn't detected, but that was their choice to not look for that issue. And that was their responsibility. Doesn't work in a negotiation, because the other side's going to entrench, because they're going to get defensive about their client. But if you talk about the problem, which is the mold, the problem is the medical bills. The problem is the continued issue that is ongoing. The problem is that the business can't continue any longer, that the two of them started, and both of them are now losing money. Look, both of our clients are losing money right now. They're not able to work together on this business. Clients are hemorrhaging off. We've got to figure out how to break this down and break it apart that works for both sides, that is, we can live with this. One factor we can use is, right now, we know the time to trial in Harris County has gone up dramatically. Before COVID, it was about 18 months to 2 years. It's almost doubled because of the backlog, which is still having to get dealt with. There's a page on the website you can go look at on justx.net. It shows you we went from 40,000 cases to 70,000 cases. We got the same number of courts on the civil side. It's a lot of cases. So, look, we are so far out from trial here. I don't think you and I want to be living with this case for the next 4 years. Neither do our clients. So taking the language away from the direct, saying you were wrong, and saving it for that moment that you need it to have the maximum amount of impact, because that's your line in the sand moment. That's the moment when you are not worried about building rapport anymore. Well, you are not worried about, and things. You've got to put the line in the sand. Like, no, this event happened. This thing happened. In a case, I lots of them, but in a recent case, I had a business owner who was there as the rep, okay, but wasn't the person that was involved in a set of email exchanges. And he kept telling me what the emails said. And I pulled the emails up and I said, but John, that's not what they say. The other side said, I don't understand why you're saying this is a problem. And then your person decided to handle the problem in a particular way that became the basis of this lawsuit. Now, how you understood that conversation to have happened is different than what my written documents that a jury is going to be making a decision off of are doing it. So I burned up a lot of rapport I built with this guy. And he was an old school maritime guy, really, really old school, kind of salty. And yeah, I was not thrilled with being a female mediator, but I built rapport with him by sharing my knowledge and just, not letting him faze me. And I have a lot of stress balls, by the way. I'm on Zoom a lot, so a lot of stress balls all around my desk. But I had to burn it up. I had to burn that tank of rapport because there was that point where the line of sand had to happen. But because it was the first time I had put that line there, it was far more effective because I wasn't just saying everything was an issue. I was saying this was the issue. This was the thing that everything else was going to turn on. And when a jury looked at that email, they're not going to take it as the way it was explained to him by one of the people in his office that was involved in the email exchange. They're going to look at the email exchange and they're going to see what it says. And that's how it could be reasonably interpreted by a jury. And lastly is giving people time. Negotiation is a process and processes take time. People need time to read. One of the things that doesn't get used enough, either in mediation or negotiation, is allowing the other side time. People talk about keeping pressure on a negotiation. Gotta keep the pressure on. And they take that to mean that we have to constantly be badgering for answers or agreements. And that's not necessary. Pressure could be in other ways, which is, I need to wrap up this issue by X date. This has got to get resolved before the deposition. We need these discovery responses for the deposition. Otherwise, we've got an issue because I can't properly do the deposition and you're going to be supplementing and I'm going to be redeposing and nobody wants to go through that. So you can keep the pressure on that way, but giving people time to consider what you've told them and process it will get them past their emotional response to the discussion that you were in and focus on the fundamentals of what was in there. Because you're going to be telling things to people in negotiation and in media and in the law they don't like hearing. That's part of what we get to do. We get to be the bearers of bad news. So I've got time for one end-up question if anybody's got one. All right. I've got 4 minutes left, but that's oh wait, I got a Q&A. Yay! Okay. Okay. I love this question from Janet Jaskier, and I hope I pronounced your name correctly. But as young lawyers, how do we combat negotiate against more experienced attorneys who may try to take advantage of us for having less knowledge and experience? Really? You've tried this case before? This exact facts? Oh, okay. How'd that work out? Tell me about the trial. All right. All right. That sounds a little different here. I mean, that was an 18-wheeler case and this is a minivan versus a minivan. How is that applying? Oh, okay. Oh, when was that case? It was 20 years ago. Laws changed, right? In a recent case that I tried, in a recent case that my partner tried. So first of all, listen to them. Let them tell you how amazing they are. Everybody likes to talk about themselves. They want to talk about how amazing they are, how fabulous they are, and you're sitting there going, oh my God, like you're 92, please retire. Right? But doesn't mean that they're right, but let them talk about their experience. Let them puff themselves up like a giant peacock. Listen, take notes, and then come back and go, okay, all right, well, based on your experience we've done before, we have to do this next step. We have to deal with this next. Well, this was different from. So it's differentiating and it's stating, don't ever call yourself inexperienced or young. You're an attorney. You're a member of the bar. You're as equally qualified to be there as every other lawyer and just as equally qualified as them. Give them space to talk first, take lots of notes. And you also find that they actually are that experienced because sometimes, honest to gosh, they're not. They think they are, but they're really not. And you'll have a better sense of also what you're dealing with an opposing counsel. You can focus on process questions to get that part moving and to get more details about their claim. None of this is perfect, but it's a consistent methodology that if you use these open-ended questions, you will get so much, especially if an attorney is flexing the "I know more than you. I've been here before." Some of them mean well, like some of them think they're actually mentoring and they mean well. So listen to what they have to say. It might be useful. You might have a few minutes to, you know, write your grocery list, whatever. It's, you know, it's the investment is time. And I found especially people that want to flex their expertise, that if you give them that listen, they actually respect you more. Whether or not you care if they respect you at all. All right, I think I'm supposed to wrap up close to 12 o'clock. I'm super easy to find. If you ever have any questions about negotiating a case, mediating a case, even if I'm not your mediator, it's cool. I live to teach negotiations. This is one of my favorite things to talk about, and I can nerd out for days on end on scenarios and issues. But I'm easy to find on Facebook. My email is right on my website, which is petersonadrtx.com. I will write this in the chat if I can. Can I do everybody? No, I can't. I can't do things in the chat. I will make sure. I think it's was on the CLE information part. But feel free to talk to me. I'm also super easy to find on Facebook Messenger on Facebook. For whatever reason, the majority of lawyers in Texas love Facebook, which is why I'm on there. So that's where most of my Messenger stuff is. But I'm always happy to set up a time to talk about negotiation or specific problems that you're running to deal with. Oh, thank you, Harriet. I appreciate that so much. I'm happy to set up a time and do that because it is a lot. And I think that talking about all the other things that go into making a negotiation easier, it sounds simple on the front, but which I put in practice sometimes gets a little harder. So, and yeah, thank you all for your time. I hope you had a lovely lunch along with listening to me, and happy Valentine's Day. May your day be filled with flowers and chocolate. And I hate to hear we're going to get sunshine around 4 o'clock. So some of that too. So take care, everybody. Bye-bye.